at this point, we get to talk with international law expert Atty. Romel Bagares, still about the developments happening at the ICC hearing. Good evening, Attorney. Thanks for being here.
Good evening to everyone, to our viewers. It's a pleasure to be here.
Okay, so I know you're also following the confirmation of charges hearing, and we just heard the first session in day 2 where the prosecution submitted their submissions on the merits. What did you make of how Attorney Edward Jeremy laid out the premise for the charges against the president?
I think it's very systematic, very much on point, because here, there are 3 things that the prosecution must present with respect to. This is now, we're talking here now of the detailed presentation of the evidence. The first one would be the contextual elements showing the widespread or systematic nature of the attacks against civilians. And the second one is the discussion on representative incidents. As you know, there are over 500 victims here, but you cannot present all of them. You need to have representative cases, or what scholars call iconic cases. That was taken up by the prosecutor. And then you have linking conduct to modes of liability. And we saw that in the juxtaposition of video statements of the president and the consequences, the corresponding result of such statements, as seen in the implementation of the Upland double barrel and the Upland double barrel part 2, or reloaded for that matter.
Well, the prosecution is expected to submit more of their arguments later on. We're in the midst of a 30-minute break. But let's go back, Attorney, to what happened yesterday in day 1. We saw all parties delivering their opening statements. And if we were to compare this to a boxing match, who took round 1 for you?
Well, I think that
Hey Google.
this is really the prosecutor's show, because for the first 2 days it's going to be the prosecutors who will be discussing the evidence. The third day will be reserved for the defense to show their counter arguments and their counter evidence, right? So right now we're seeing actually that the prosecutor was able to show in the first day, for instance, the dramatic presentation, all the videos. I keep on telling people that Mr. Duterte is really the first president who was elected via social media. And we can also show that all his statements, and this is really unprecedented in terms of the amount of evidence on video, the recordings, televised, online streaming, compared to all the other cases discussed or taken up in the ICC before. You have a head of state with just an immense amount of evidence linking his statements to killings coming after the statements.
I see. Well, the judges of the pretrial chamber did make it clear, Attorney, that the threshold here isn't to prove guilt or to decide on the innocence of the accused. What they're doing here is just to determine the sufficiency of the grounds if this can indeed continue to a full-blown trial. But as you mentioned, we heard the prosecution leaning heavily on the public pronouncements made by the president. But aside from that, they also relied on the insider testimonies. The witnesses, the names of witnesses were not revealed just yet, but they already talked about how the alleged Davao Death Squad was formed. They described what happened in the meetings, guns were being handed out, and Mr. Duterte was giving instructions. From a legal standpoint, how powerful is that kind of testimony here at this stage?
Well, there are 3 counts being presented here. They begin in Davao, then you have the high-value targets operation, and finally the barangay implementation of the double barrel campaign. And these 3 things are not are wholly related, they're integrated. So the prosecutor is showing a pattern of conduct that started in Davao, and when Duterte became president, the same pattern was actually expanded and implemented on a nationwide level. So you can see that here the prosecutor is trying to show that what the commentaries on the Rome Statute say is the need for robust prima facie evidence, which translates to substantive evidence showing that the accused committed the crime and should be brought to trial, right? In fact, that mirrors right now almost mirrors the standard we have in the DOJ, because they shifted to prima facie evidence as well, no? So there are other commentaries that say that it's equivalent to preponderance of evidence, that there is a strong indicia of guilt. But it's not quite the same as guilt beyond reasonable doubt when you go to trial. So looking at the presentation so far from this first day to the second day, systematic, and there's really an effort on the part of the prosecutor to connect policy made by the president, as written also in a memorandum issued by the PNP on Upland Double Barrel, and how these orders, this systematic policy, how these were implemented on a nationwide level.
And in detailing how this Upland Double Barrel worked, we saw Attorney Edward Jeremy there zeroing in on the word neutralize. He said this appeared in the guidelines that were the guidelines for implementation distributed to high-level authorities, even signed by then PNP Chief Bato de la Rosa. How crucial is it for the prosecution, attorney, to define and contextualize what neutralize means during the Duterte drug war?
Well, it's important, a point made by the prosecutor, that there is no equivocation in the meaning of the term neutralize. It means kill, kill, kill. And prosecutor was able to show repeatedly in different contexts the president making no mistake that what he meant, what that policy meant, what that word neutralize meant is actually to kill drug suspects.
Yes, and then you also have Attorney Jeremy showing the PRRD lists. Lots of names, faces included there. Then President Duterte did this early in his presidency. He attacked them. He publicly announced individuals who he said are allegedly involved in drugs, and eventually some of them even ended up dead. But is that enough to establish sufficient grounds, attorney, to prove that Mr. Duterte was criminally responsible for that?
Well, this was the second thing that I pointed out earlier, what the use of representative incidents versus totality of conduct, right? So right now we're not yet on trial, but this is a crime against humanity prosecution. And the practice of the ICC really is just to look at representative incidents. So you saw there in the list the case of the mayor who was killed in the in jail, Kian de los Santos, a few others in the Davao incidents. Right, these are what we call iconic cases, and the point really for the prosecution is to show that these cases indicate how the policy was implemented, and that the policy really meant to have a systematic and widespread attack targeting civilians.
Well, speaking of a systematic attack, Attorney Jeremy also laid out what happened during Upland Tokhang, which was targeted at the poor because they're allegedly the ones who don't have the means to file any complaint. And what appeared multiple times, he said, in police reports was the word nanlaban to justify why authorities, law enforcement, shot alleged suspects in an act of self-defense. Is that enough? The reports using the word repeatedly, nanlaban, is that enough to establish systematic attack under crimes against humanity?
You know, when I was active in human rights litigation, I was also involved in some way in the investigations on the killings, and you see that repeated all the time. It's the same script. In fact, the way the police reports are written, they tend to sound the same, even if the events happened in different parts of Metro Manila. And then in the presentation, there was the prosecutor zeroed in on a one-time victim operation in Bulacan, 32 people dead. And the president exalting and praising the police for doing that and saying that we need more. If we can only have 32 more people dead on a daily basis, then perhaps we will be happy. We will be able to meet our goal of ridding the Philippines of drug addicts. No, and that just on a 24-hour period, you have 32 victims killed in a one-time victim operation. That to me is a clear instance of a systematic and widespread attack targeting civilians, and that in itself, just that one representative incident showing that you have a multiplicity of victims being killed by police in just one operation.
So based on what the prosecution has presented so far, they still have the entire day to submit more on the merits. Do you think they're already meeting that threshold of the chamber for sufficient grounds to believe that Mr. Duterte committed the charges against him?
Well, I think that even looking at the presentation so far, so you have the Davao incidents, then you have the Albuera-related incident, and then that is expanded to Metro Manila. You can see that the prosecutor has been able to lay down the connection. There's a policy. Aside from the pronouncements of the president, you have a written policy issued by the PNP with the word neutralize, calling for the neutralization of suspects. The president saying that, I will answer for whatever acts you commit. I will even give you pardon for as long as I'm president. And then all the incidences, examples, no? The representative examples. I think that the prosecutor has met here, at least on this level already, the substantive requirement. But we will hear more about that. No, we have a wealth of jurisprudence in international law on pronouncements, and in fact, in one case, this is from Rwanda. You have a priest who had a regular radio broadcast, and there was a genocide in Rwanda. You probably seen that illustrated in the movie Hotel Rwanda, where you have 600,000 people killed just by machetes over a 2 or 3 month period. And this priest was inciting people to kill people called cockroaches. This is just one incident, and he was actually convicted for that. But in the case of Duterte, he's alleged to have made all these well-documented incitements as president. No, we also have our own case in the Philippines, the case of Chavez versus Gonzalez, where the Supreme Court said even if there's no written order or a memorandum, a threat issued during a press conference by a high official is an official speech act. And that can be considered a threat already. In the case of Duterte, all those 6 years was a lot of documentary, digital, televised evidence of all the statements in which the president actually actively called for killing of civilians.
Well, this is just the pre-trial stage, but we're already seeing quite strong arguments from the prosecution. So if this does proceed to trial, attorney, do you foresee even more compelling and deeply damaging evidence from the prosecution to prove that Duterte did indeed commit these crimes against humanity?
In the confirmation charges, there is no witness sitting on the witness stand. Right? It's really just the arguments from the prosecutors and the defense, and they will refer to the documentary and what relevant evidence presented to court, submitted to court by both sides. Right? But on trial, you will have live testimonies of witnesses, including the so-called insider witnesses. These are people who were actively participating at some point in the campaign with the president, who decided to turn with state or witness for the ICC, and plus, of course, the survivors of Tokang. I understand there's at least one case of a survivor of Tokang who might be placed on the witness stand. So all the drama, actually, the live drama will be seen and heard and witnessed during the trial phase of this case.
Well, we're going to hit pause first on this discussion. We're going to have you back later, attorney, to discuss more on the defense's strategy this time. But for now, thank you very much for joining us.